Is there an international trademark? Yes, there is, but it's not what you think it is. Clients are often concerned about protecting their brands in foreign countries, and that's where we come in to strategize on how best to do that. Hi, I'm Jason Rosenblum. I'm an intellectual property attorney. Protect our clients' products, their brands, and their businesses from getting ripped off. Clients are always concerned, once we file in the US or when we're strategizing how to protect their brand, about protecting it overseas as well. And there is something called an international trademark, but it's not what you would think. There is no one place you can go and file and seek protection all over the world. You're ultimately still going to have to pay the fees for each individual country. There is something called the Madrid Protocol, which makes it easier to file a single application, pay the different fees, and it kind of gets spread out to all the different countries. And then each country has their own process. And if there's any issues, you need to hire a local attorney in that country. There's also something called the Paris Convention for the Protection of Industrial Property. And what that does is give you rights to priority based upon filing in the US or whatever your home country is. So for patents, you get a 12-month window. So if you file a patent in the US, you have 12 months to file in any foreign country, and it's treated as if it was filed essentially on the same day. For design patents and trademarks, that window is only 6 months. So when we file in the US for a client, we always send them reminders that if they'd like to file foreign, they have to do it within 6 months in order to claim the priority for a trademark. You generally do not lose the right to file in another country, but you lose that priority date. And something important to know is, unlike the US, most other countries are based on who is the first person to file. So clients are often asked, because there's really no one application that covers the world, and there is the Madrid Protocol, but again, you keep paying each fee for all the different countries that are members to it, and not every country is a member of the Madrid Protocol, but many of the large players are. So the fees go up. So we always have to strategize what's best. Where is it best to file? So, most of our clients are in the US. They're selling their product or service in the US, and also a good amount of them manufacture in the US. So of course, the US is the most important. One of the next places we say is, well, where else are you going to file? Where else are you going to sell your product? Is it Europe? Is it Mexico? South America? Africa? And start considering that as a place to file. Another overlooked and important place is, where are you manufacturing? With so much manufacturing going on in China and Korea and the whole Southeast Asia region, it's wise sometimes to file for protection there, even if you're not planning to sell there, just because you don't want the manufacturer to go ahead, file before you, and then potentially block your goods or hold it for ransom, or a third party to file and block your goods from being exported, so you can sell it in the territories you'd like to sell. So there's always, a give and take, a strategy, because there is costs involved in every country to file in them. So it's always figuring out what's going to give you the most benefit for the investment. There's a few places where you can file one and you get a couple of countries, such as the EU. There is an EU trademark that covers all of the EU. So sometimes that's wise if you're going to be selling in a number of countries within the EU to look that way, as well as 2 or 3 other applications for multiple countries. But the EU is by far the largest, and the one that we mostly file in, considering where most of our clients are usually selling in the US and Europe is the large part. So again, just to round it up, there is an international trademark application, but it's not what you think, in terms of, it's not that you just file one application, it's covering the whole world. It's really one application, but you pay the fees for every country, and then it gets spread out into those countries and essentially turns into individual applications in each of those countries. It's more of like a simplified process for filing, and assuming everything goes through smoothly, then you can kind of manage it that way easily. But as soon as there's any issues within any of those countries, generally you have to deal with it on that individual level. In terms of strategizing where to file, of course, the country you're located in is one of the most important, especially if that's where you're selling, manufacturing, or developing the product. Then you look at where you're going to plan to sell it or are selling it in other countries, and also where you're manufacturing. Or something I failed to mention earlier is a lot of our clients are into software and they're developing software. They're using developers all over the world. That also might be wise, to think of it on the same level as a manufacturing, that where your developers are, you might want to have protection there as well. Jason Rosenblum here. Feel free to reach out to us. We're at 888-666-0062 or jhrlegal.com. And feel free to subscribe to this and let us know if you have any questions that you'd specifically like answered. Thanks.